The Honourable David Cunliffe.
Mr Chairman, New Zealanders have been thinking for a while, feeling in their guts that there's something just not right with this government, that they're arrogant, that they're increasingly out of touch, that more and more they are looking after the mega-rich, not most Kiwis, that they stand for the influence of big money, not for the Kiwi dream of ordinary New Zealanders. And then once or twice along come some little nuggets that the average Kiwi can say, there, that's what I've been feeling, that's what I meant, that's what's wrong. And this week, sir, we've seen two of them. Very briefly, sir, the Prime Minister saying to his personal trust lawyer, go and fix it with Todd McClay around the secrecy, the enduring secrecy of foreign trusts. And he did that, sir, and Mr McClay the very next day, cap in hand, went to see the same personal lawyer of the Prime Minister. Did the Prime Minister recuse from that? No. Did he declare it? No. Did he maintain the standards required? No, he did not. And now we find, sir, that the same trust lawyer has been donkey-deep in dodgy deals, defending known bankrupts and effectively witnessing documents that weren't even signed in New Zealand. That is the sort of thing ordinary Kiwis say is just not right. Because in the last week we've seen the Overseas Investment Office. That's the body that we as New Zealanders rely on to keep us safe from international tax evaders, scammers, people of questionable reputation who want to buy New Zealand land and assets, but in so doing would bring into question New Zealand's international reputation. You know, in the last 5 years, that Overseas Investment Office has approved 99.85% of all applications put before it. They've only turned down one solitary application, and that was after it spent weeks in the media, Lochinvar Station. And the Prime Minister had the gall to say the problem with the OIO is it takes too long to give the wet bus ticket. It should be sped up. And bring on the case of Onitai Station. That's the case that turned up because it was linked to those infamous Panama lawyers, Mossack Fonseca in the Panama Papers. The case the Minister wouldn't tell us about. The case she didn't want you to know about. Louise Upston wouldn't name them. But we found them. And we also found, sir, that the owners of the shell company, Keole and Muir, who bought the Onitai Station in Taranaki, actually had criminal convictions, criminal responsibility for toxic waste pollution of their local river in Buenos Aires, even though environmental considerations for water purity, wait for it, it's hard to believe, were part of the consent to come to New Zealand. They had carcinogenic chemicals in their river at home. They got a conviction for that, but the OIO missed it. They relied, how did they miss it? Firstly, they relied upon a thing called a statutory declaration. That's where the lawyer says, my client's clean. See, I've signed this. You know what that was worth? Absolutely nothing. But routinely, that's what the OIO relies upon to keep us all safe. That's just wrong. Secondly, they couldn't even do a proper Google search. They said they tried a Google search. Initially, they said they didn't find anything, and later they said a junior staffer who no longer works there found something but didn't tell anybody. Well, it took the Labour Party half an hour to find those criminal convictions, which should have prevented that transaction going ahead. But there is, sadly, more. One of the directors of the shell company that purchased Onitai Station is, according to UK Companies Office records and Florida court documents, associated with another company, a director of another company that was associated with an alleged major tax evasion scandal involving a national soccer coach, Mr. Scolari. That case was settled out of court, but it called into question the bona fides of the lawyer concerned, one of the Panama lawyers who set up the company that bought Onitai Station, and I'll shortly be tabling the documents that substantiate that sorry story. Thirdly, OIO documents show that the OIO's lawyers could not even be sure who the final owners were. That adds up, Mr Speaker, to a tale of woe of an organisation that is not keeping New Zealand safe.
The time for this debate has expired. A point of order, the Honourable David Cunliffe.
Thank you, Mr Speaker. I seek leave to table several documents which pertain to the matters just raised in my remarks. Mr Speaker, first I seek leave to table the OIO's report to the Associate Minister of Finance and Minister for Land Information dated 10 December 2013 that recommended that Raphael and Federico...
We don't need the recommendations. It's just a description of the document.
Thank you, Mr Speaker.
And with it, an assurance from the member that it doesn't come from the website.
Mr Speaker, no, this was obtained under the Official Information Act.
Okay. Is there any objection to that document being tabled? There appears to be none.
Mr Speaker, I seek leave to table a certified translation of media reports from Argentina dated 22 March and 28 March 2011, which report that the Grozovsky brothers were found criminally responsible for toxic dumping in Argentina in 2011.
I think we'll make the exception given the fact that it's a translation rather than in Portuguese.
Certified translation.
Sorry?
Certified
rather than just a direct media report.
Certified by one of the DIA's official translators.
I think it'll be easier for members to access the translation. So I'm willing to put that. Is there any objection?
Thank you, Mr Speaker. Thirdly, I seek leave to table court documents from Argentina dated 12 March 2007 and 29 March 2012 that show the Gorovsky brothers were found guilty of toxic dumping causing serious health risks, including lung disease and cancer.
Is there any objection to those documents being tabled? Appears to be none.
Mr Speaker, I seek leave to table several documents relating from the UK Companies Office in the Florida Southern District Court that show Gustavo Daniel Chavez Mantares, a director of Keol and Muir Limited, was also a director of Charterella Investors Limited from May 25 to September 2015.
Is there any objection to those documents being tabled?
Mr Speaker, documents dated 30 May 2005 that show that Mr Mantares was appointed as a Director and Secretary of Charterella Investors Limited on that date.
Is there any objection to that document being tabled?
That is UK Companies Office.
Yeah, we had a prefix, I think, for these ones. Yep. Hang on, better put it. Is there any objection to that document being tabled? Appears to be none.
Sir, I seek leave to table a document dated 8 July 2014 that shows that Charterella Investors Limited changed its name to Inmax International Limited on that date.
Is there any objection to that document being tabled? There appears
Sir,
to be none. Just before the member goes on, can we maybe do the British ones together?
Sure.
Any more?
That's one more British one, sir. And that is a document dated 30 September 2015 that shows that Mr Mantares was terminated as a Director and Secretary of Inmax on 30 September 2015.
Is there any objection to that document being tabled?
And, sir, finally, a court document from the Florida Southern District Court dated 5 May 2014 which states that the Portuguese tax authorities, and I quote, have reason to believe that Charterella Investors Limited was used as a vehicle for alleged tax evasion by Mr Scolari, a national soccer coach, between 2003 2008. In so doing, I note that matter was settled out of court.
Okay.
So I seek leave to table those Florida court
Is there any objection to that document being tabled? There is objection. Are there any further documents?
That's all, Mr Speaker.
Right, I now call on private and local order of the day.